right, so this is David Miller with the Miller Group of Keller Williams Realty, and today I'm interviewing Don Morrell, and he is a probate attorney. He works with Kendrick Law Group, and he's been with them for about 6 years. And I thought it'd be a good idea to talk about probate because you probably heard about it before, and you may not know what it is, like most people. So I thought, let's bring in an expert who does it all the time, day in and day out, and we can sort of ask him some questions. So Don, first of all, welcome. I appreciate you coming on board here.
Good morning. Thanks for having me.
Absolutely, absolutely. So Don, first of all, why don't you share with everybody what probate actually is?
In a nutshell, probate is a court-monitored procedure whereby we find the assets of an estate, ascertain what liabilities they are, pay what we can of the liabilities, and then distribute what's left over to the beneficiaries. And it's again, I started out by saying it's court administered. So some of the things people think happen with probate, they do happen, but they can't happen without the court approval. And that includes oftentimes the sale of the home.
Okay. So if we talk about it from a real estate perspective, because that's where I see it mostly,
Sure.
is somebody passes, they don't have, is it when you don't have a will or a trust or something that tells them what to do, then the state sort of steps in?
Well, one of the, let's back up just a little bit and let, as it pertains to real estate, when does a client need probate? Well, the simple answer is they're going to need a probate if the asset, the home in this case, real estate, land, home, or property, real property, is in the sole name of the decedent. The only way to transfer that property in the state of Florida is through a probate action.
Okay.
That's really in a nutshell what you're going to need for real estate. Is the home solely in the name of the decedent? In that case, you're going to need probate before it can be sold.
Okay, that makes sense. That makes sense. So if it does have to go through the probate process, is somebody able, if they're wanting to sell the house, like they don't want to keep the house, they want to
Right.
sell the assets, do they have to wait until probate's done, or are they able to do it at the very beginning? How does that work?
So probate, let's just talk about probate in general, and then I'll get to the specifics of your question. So there's two types of probate, and you alluded to that a little bit earlier. There's intestate and testate. With testate, it means that there's a will, and that will acts as a roadmap for the court to follow for the distribution of the assets.
Okay.
Intestate means there's not a will, and that in that case, then the asset home gets distributed to the heirs at law, and there's an intestate succession in Florida statute that details how that property is distributed. So once we determine if it's testate or intestate, there's still more to think about, and that is what type of probate are we going to have? Are we going to have a formal administration, or are we going to have a summary administration? There's some requirements for a summary administration. One of them being the assets of the estate can't be greater than $75,000. I tend to lean towards a formal administration when there's real estate involved, because now we have a person that can deal with the court, that person being a personal representative. And I find that if we look at a 10,000-foot view of summary versus formal, you say a layperson could say, well, summary administration is going to be quicker, I'm going to go for that. Not always the case as it pertains to real estate. And I try to push people toward the formal administration when there's real estate involved to go ahead and do that. So now that we've determined what kind of probate action we're going to have, as I say, we're going to do a formal administration of an estate where there is a will and the will's left to the children. That's a common misconception too for some people. They feel that if the will gave them the home or devised the home to them, that they own the home. You still need a probate in order to make that happen. And unfortunately, as you've probably seen, a lot of people don't realize they don't own the home until it gets time to close, and the mortgage underwriters have had a chance to look at that file and determine that a probate action needs to be done.
Yeah. Yeah. Now, let me ask you, looking at everything in general, what percentage of houses have to go through the formal probate process compared to people that have already done a will or a trust, would you say?
If there's take a trust out, because when there's a trust done, if the home is transferred to the trust owns the property and not the decedent. So back to my first answer,
Gotcha.
it's not in the sole name of the decedent, so you probably don't need probate for that. Now there may be some trust administration, which is different than probate.
Okay.
But as far as a home, if it's in the will, it's still going to need, and it's in the sole name of the decedent, it is still going to need to be probated. Now, if it's a husband and wife and one of the spouses passed away and the deed was done correctly, then it should automatically pass by law to that surviving spouse. However, there are some steps that need to be taken to ensure that the title is clear. It's not a probate; you just need to file a death certificate and probably an affidavit of continuous marriage, and even though there's no estate tax here in Florida, you still have to file an affidavit of no Florida estate tax
Gotcha.
to make
Gotcha.
that happen. Yes.
When you start the probate process, how long does that typically take?
So let's just say we filed a petition today, and that person has been through the will determined to be the appointed personal representative. It still could take up to 4 weeks to go ahead and get appointed as a personal representative in that, even then. If it's an intestate, there's no will, or the will doesn't specify a personal representative, then all the heirs need to be notified, and it could take longer. There's an opportunity for them to go ahead and complete a consent or waiver, if you will, or a waiver of notice and consent to that personal representative, and that could speed the process along and still get you in that 4 weeks. So the typical lawyer answer that we give is always, it depends. It really depends on the specific facts of the case and who's involved, and the number of heirs that are involved as well.
Okay. Okay. So if I have a property, it's going to go through the probate process, do I have to wait until we're done with probate until I put it on the market so it is marketable? Or am I able to do it beforehand? Or do I have to wait till probate's done before I can close? How does that look from a time?
Yeah, so I would, okay, probate, for the probate to be done, and let's say a formal administration, that could be up to a year. So no, you don't have to wait that entire time before the property can be sold. A couple different things to think about and look at is the property itself. Was that property the homestead of the decedent? That term homestead in Florida has a few different meanings. With a probate, it being a homestead, that means that that property, that asset, can transfer to the heirs without being able to be attached to the creditors. So it would pass credit, debt free to the heirs. However, that takes time in and of itself. The underwriters can approve the sale without that order determining homestead on their own, based on some metrics that they have, and the house could be sold in pretty quickly as far as that goes. As soon as the personal representative is appointed, the home could be sold, and then all the heirs could sign. They would sign the deed. It wouldn't be a personal representative deed at that point, but all the heirs could sign the deed and transfer the property. It can also be sold after the order determining homestead is granted by the court. Again, this is going back to my initial comments that this is a court administrative process. So the court is the one that determines if it's homestead, not the individuals. And in most cases, there's not an issue to do that. However, many jurisdictions, the judge will wait until the termination of the creditor period before they will sign that order. There's also another way to get the property sold, and that would be get an order authorizing the sale through the court, and that can happen as well. If the property is sold prior to, I know I'm dragging on here, but if the property is sold prior to the order determining homestead, and prior to the creditor period expiring, in all likelihood, those funds are going to have to be kept in a separate account until that creditor period has expired, before those funds can be distributed. But the property can be sold, which is a great benefit to a lot of personal representatives and beneficiaries, because they don't have the money to keep that house going, and the upkeep and the mortgage and utilities and all that. So
That's
it's
good
helpful in
point.
that case.
Yeah, if you have an HOA
And
fee, utilities, property insurance, taxes, all that stuff is the responsibility of the people that have it at that time, right?
that is correct. And I'll digress just a little bit here. A foreclosure action can be started or begin during the uh, probate period. Once the probate is started, it's not going to stop the foreclosure from happening. Um, a lot of people are confused by that, and the bad thing about that occurring is that the fees go up, incrementally as the foreclosure, because that those fees are attached to the property.
So basically, if you have a property that was in, let's say, dad had already passed, mom's still alive, she passes, it was deeded in her name, and she still had a mortgage on it, it's still important to keep that mortgage paid and up to date. If not, it can slip into foreclosure. And then there's additional fees that obviously the banks charge when you're so far behind. Is that correct?
Absolutely. And a lot of times what happens is the mortgage was behind before the person passed, and the family personal representative had no idea that was going on. So now that puts you closer and closer toward the foreclosure period.
Gotcha. Yeah. How about if the parent is in a different state? Do I have to file probate in that state, or can I do it just from Florida here? How does that work?
So and this happens a lot in Florida, because we have a lot of snowbirds or people that are from the Northeast and other states, and that's where they live, but they have real property here, either condominiums or vacation homes down here in Florida. And cases like that, here's the lawyer answer again. It depends. What it depends on is, was there a probate that was started in their domicile state? So if someone lived in the state of New York, they probated their assets there, and but you still have a home here in Florida, or a condominium, vacation home, if you will. What we need is an ancillary proceeding here in Florida, because the only way to transfer real property that's solely in the name of a decedent is through probate, and we'll have to do that probate here in Florida as well as their home state. Um,
Yeah.
and I have had instances where they didn't need a probate in their home state, and they just had the property that was here in Florida, and we just went ahead and did a normal formal administration of that property for the state of Florida.
Last question for you. If you have to go through the probate process, is it something that you could do on your own, or is it something that you highly recommend you get somebody that specializes in it to do it for you?
There are, as I've gone through our little discussion here today, you've heard some of the nuances and things that go on. There is the possibility that you can do it on your own if you're going to do a summary administration, or there are other types of administration that I didn't cover, that aren't normally. It's for really small estates or really small accounts, and you could do an administration without or a distribution without administration, but it has to be real small amounts. A person can do that on their own. However, if you need a formal administration, you're going to require an attorney.
I guess my advice would be, if it's something that you haven't done before, and you probably want to get somebody that does it all the time, that can sort of guide you through it, make sure you're making, provide you the proper information to make you help you make informed decisions, so you can get to the end result probably quicker than you could on your own. Is that
Absolutely.
correct?
What I was going to say, I mean, we need to get from point A to point B with property, and as I said, there's different ways to accomplish that. The best way for a person is really dependent upon the individual facts of that case, and unless they know how those facts impact the law and the ability to get something done, it could take a lot longer. Particularly selling the house, and as we stated, the longer it takes, the more costs you're accruing and fees and whatnot, and it's money well spent to get it done and get it done right the first time.
Makes sense. Makes sense. Well, Donald, if somebody is in a situation where they have to do probate, I'm going to provide your contact information either above you or below you, and then that way they can reach out to you. Is there a good number they can call you on, though? You can put out there right now?
Sure, it's 407-641-5847. And I do want to add that, my consultations are free. Come and talk to me, and I'll give you the information and let you run with that and see what you need to do as far as the probate. Today I had a consult with a new client for probate for their mom's estate, and as I looked through everything, they didn't need probate. I just advised them what they could do to get transferred. And get things taken care of. But more importantly, I let them know that they came in for their mom, but their dad is still living. And that's, when one spouse dies, you got the other one still living, that's where you want to kind of take care of things so that follow up, you don't need, when that person dies, you don't need to do the probate for them, or minimal amount of probate.
So it pays to do that work up front. So on the back end, you don't have to probably double the amount of time you put into it at that time, it sounds like. Is that correct?
Absolutely. And it's really an emotional time as well when a loved one passes away. And the more you can have taken care of, the better off you'll be. And the decedent is better off too, because they know that their stuff is taken care of ahead of time, and they know that you're going to take care of it the way that they want it taken care of.
Absolutely. Absolutely. Well, Donald, I really appreciate your time and taking the time to come on and ask you those questions that a lot of people probably were asking themselves. So I appreciate your time. And like I said, if you need to reach out to Donald for his help, just reach out to the number he mentioned, which I'll put down below us here as well. And Donald, I hope you have a great day.
Thanks, David. You have a good one.
All right.